and Thales will be resuming. Ayanda, what are you hearing outside of court? What's the earliest reaction?
Yeah, thanks very much, Desiree, once again, and good day to our viewers. Still waiting, of course, Desiree, we had earlier on has spoken to the NPA to get their reaction to today's judgment. And of course, the NPA, this was a victory for the NPA, which has now said that they are simply now waiting for the start of the trial. Earlier on, we spoke to Advocate Mhlongo, and I guess the next step now is for us to hear from the Jacob Zuma defense team, or the spokesperson for the former President Jacob Zuma, Mr. Mhlongo, who is inside court and should be coming out shortly. We do know that the former president has now left the court. Just to speak a little bit, Desiree, around, I know there's a lot of interest with this case, as always, in terms of what happens outside the courtroom, and I'm just trying to buy time until we get Mhlongo to come and join us and give us the reaction from former President Jacob Zuma in terms of how they're going to proceed with this matter. We did hear from Advocate Masugu inside the court that there is some intention from former President Jacob Zuma's team to possibly appeal this judgment, and so we'll hear from them in more detail in terms of how they plan to proceed with this matter. Of course, as you said, the 11th of April 2022 is when this trial should get ahead, if there are no other applications that are brought between now and then. Of course, the judge also then saying that the representative of the French arms company Thales, Mr. Durant, who has previously been excused because he resides in France, that he will have to be present in court on that day. I'm just looking outside, although earlier on, as I said, we were not expecting today that the former president was going to be inside court. And as you know, whenever he is here, there is large crowds that gather outside the court. Not a lot of people that have come out here today to show their support to the former president, but there is indeed a heavy police presence outside the road. Outside the court has been cordoned off, and in fact police officers around the precinct of the court and access inside and outside of the courtroom A, where the matter was sitting, also restricted. And there's heavy security around courtroom A. Let me now continue and bring in our legal expert, Mpumelelo Zigalala. Thank you so much for continuing to stay with us as we wrap up today's proceedings. The trial now set to start next year on the 11th of April 2022, but there was some indication from Advocate Masugu that there could possibly be an application that the former president might file or to review this judgment, as you had said that it was expected that they might take that route.
Definitely, and you must remember, just remember the utterances of the judge of saying that I'm bound by the decision of the highest court or the court above me. So basically saying, if you want to move away from this legal principle that has been adopted, your best bet, go to the Supreme Court of Appeals and check whether they can be able to amend or extend or adopt a wider interpretation of the no charge to prosecute. I do see this matter even going to the Court because it touches on matters of your constitutional rights, Section 35 to be precise. So they'll definitely say, please, Court, can you decide this matter once and for all? Let's really decide what the title to prosecute actually means. Let's look at the conduct of the prosecutor in this case and give us direction to which legal principle must be adopted when it comes to the jurisprudence in South Africa.
Earlier on, as you were unpacking the judgment for us, you spoke about obviously the timing of the special plea application, but the fact that the judge has somewhat said to them, or rather to the former president Jacob Zuma's defense team, that allow the trial to start.
Yes.
And should you then wish to file an application directly speaking to the independence of Advocate Billy Downer, that would be the right time then to do so. Again, when I take from what the NPA is saying, the NPA is saying that the evidence that has been brought forward, or the arguments rather, that were made in the special plea application by the former president were the same arguments that were made in his permanent stay of prosecution application. Would that not mean then they would, as the NPA said, simply be regurgitating old arguments, even if they were to bring that application when the trial starts?
But I think it also depends on the type of analysis which would then be applied to those type of facts. The facts could be similar, but depending on the legal principle in which you want to advance or you want to go against, that's the most important part of saying what legal principle am I fighting in this case, what are the facts that must be considered by this court when determining those legal principles, and then how do we take it on from there. I always say, if there's a legal avenue open to the former president or to any other person, they're at liberty to traverse it, so that at the end of the day, they are exercising their rights as entrenched in the Constitution. So the judge said here, if your application was brought in another format, maybe I would consider it and think and decide it in a different manner. However, you've confined yourself to Section 106(1)(h) of the Criminal Procedure Act. I can't do anything about it. I'm bound by the Supreme Court of Appeals case. I'm bound by the principles that have already been assessed and been given to us by a court that is higher than us. I have to give this particular decision. But it doesn't mean that if you bring in an application now on a different slate, even though the facts are more or less the same, however, you are looking for something which is different, certainly the court is obliged to look into this particular process.
I just want to go back to one point, and I asked this to Advocate Mhlongo of the NPA, and this is regard to the criminal case that the former president has opened against Advocate Billy Downer for accusing him of misconduct. The NPA says that, as you had said earlier on, that these are two separate matters. The criminal case is separate from what was now the special plea application, and the NPA is now saying that decision must be made by the Director of Public Prosecutions here in the province of KwaZulu-Natal. Should the DPP in KZN then decide that there is reasonable evidence that has been brought by the former president to charge or to go ahead and charge Advocate Billy Downer, what would then happen in terms of this case?
In fact, the NPA will then have to say, let's remove you, Advocate Billy Downer, from this matter. We don't want to taint the merits of the case. We don't want to taint our ability to get a conviction merely because you have been found that you have contravened this particular act, especially because the facts surrounding your suspension or your removal are directly linked to the conduct or the manner in which you've carried yourself within this particular matter that you are dealing with. For reputational damage precautions, for precautions that we want to win at all costs, so that there's nothing that will taint our ability to win at a later stage, let's remove you. You are too involved, you are too tainted, there's a dark cloud over you. You can't then proceed to prosecute in this matter. It is, I think, in that instance in which Advocate Billy Downer will be removed. And it would be very beneficial to the NPA, because at the end of the day, they will be able to proceed with the prosecutor who is not tainted, with the prosecutor who is not being followed by any dark cloud. Let's remember, I don't think the investigation into the conduct of Advocate Billy Downer pertaining to the charges that were laid last week will be complete and done and dusted by the 11th of April. So on the 11th of April, you come here with the prosecutor. Maybe by that time was already been charged. So definitely it would be in their interest to say, let's remove you, deal with the contraventions in which you have alleged to have done separately, but let's get another person to continue with this matter, because we want to start and end it within the shortest amount of time.
We said the last time, 2018, the charges were reinstated. We're now at 2021, and we still haven't yet reached the actual trial. So I suppose we still have a long way to go.
My prediction, if I put my head on the block, I think the whole of 2022 is going to end without us having heard the first witness in this particular matter.
Thank you so much, sir, for your time there. Desiree, you heard we still got a long way to go with this matter, with the options that the former president Jacob Zuma has in terms of reviewing or taking this matter to a higher court to review this judgment by Judge Piet Koen. But we are back on the 11th of April 2022 for what the NPA has says it hopes will be the start of the trial. Remember that just before the special plea application was filed at this court, the NPA had already brought down its first witness. Ms. Patricia de Lille was present in court and had been ready for the estate, and of course then the former president filing the application, the special application to seek the recusal of Advocate Billy Downer. That has not been successful, so we'll wait and see whether or not on the 11th of April next year this case or this criminal trial against the former president will will finally get ahead. Desiree?
Ayanda, thank you so much for that sterling reportage. And former President Jacob Zuma's special plea to have Advocate Billy Downer removed has been dismissed by the High Court sitting in Pietermaritzburg in KwaZulu-Natal.